Just a quick overview of the initiative. We're working on the echo. Sorry about that. A quick overview of the initiative. Again, the Initiative 502 was backed by New Approach Washington. It passed with a pretty strong vote there, 55.5%. New Approach Washington raised about $6 million to promote the initiative. The No campaign was not as well organized nor nearly as well funded. They raised about $16,000. So just kind of some scale there in terms of how the initiative passed. For some perspective, Oregon and Colorado also had marijuana legalization initiatives on the ballot. Colorado's passed, Oregon's failed. So we are going through a similar experience as Colorado right now and trying to figure out the impacts of this sort of initiative. Just some important dates to remember in terms of the effective dates on the initiative. December 6, 2012, so next week, decriminalization of possession begins. That includes any combination of 1 ounce of usable marijuana, 16 ounces of marijuana-infused products, such as marijuana-infused butters, or 72 ounces of marijuana-infused liquids. It's not legal as of December 6th to grow, sell, or buy marijuana. Only possession will be legal on December 6th. The next important date to be aware of is December 1st, 2013, so a year from now. That's how long the Liquor Control Board has to establish rules and regulations for licensing of growers, producers, distributors, and retailers. And of course, we'll be hearing more from Liquor Control Board in a few minutes. Again, a few important points to keep in mind about the initiative. Next slide. Marijuana cannot be purchased by anyone under 21 years of age. It will still be illegal for anyone 21 and under to smoke marijuana. It's illegal to smoke, use, or have an open product in public view. And 502 did not make any changes to the current medical marijuana laws. So medical marijuana cooperatives, collectives are still unchanged under state law. We've had a number of questions about revenue associated with marijuana legalization. The marijuana will be taxed at each transaction point. Producer to processor, 25% tax. Processor to retailer, and retailer to consumer. At each one of those stages, there will be a 25% tax levied. In addition to those taxes, it will also be subject to local and state sales tax. So the big question for many local jurisdictions is, where does that money go? Does it come to us? The answer is no. Those excise taxes created by the initiative, the 25% at each transaction point, will be going to the state. They'll be distributed to the state's basic health plan, the general fund, health-related programs, and the Liquor Control Board for administrative costs. Local governments will not get a share of those revenues. Local governments will get the local sales tax portion and any local B&O tax. If somebody is going through the PowerPoints, if you could not do that right now. OFM, of course, was required to put together a fiscal analysis of the initiative, and they based their analysis on a number of assumptions. Next slide, please. They estimated that in 2013 there would be 363,000 users in Washington, and that would grow at 3% beginning in 2015 just to account for population growth. So those were some of the assumptions they used in coming up with their estimates of how much revenue this may generate. Next slide. They assumed that 18% of users would use once a year, 3% would be using daily. They assumed 2 grams of marijuana per use. There's been some discussion about that and whether or not that number is too high based on the typical person using marijuana. And so that could impact the overall revenue projections that OFM generated. Next slide, please. So you can see on this slide just over the next 5 fiscal years how much revenue could be generated from marijuana sales. The first 2 lines here, dedicated marijuana fund and state sales tax and state B&O tax, go to the state. That last line, local sales tax and city B&O tax, is what would come to local jurisdictions. So somewhere between $0 and $119 million over the next 5 years. And again, none of this takes effect until the Liquor Control Board completes its work in creating a system of licensing and regulation, which is December of next year at the earliest. So I wouldn't be plugging any numbers into your budget right now. So as far, I know we're getting a number of questions about what the local sales tax is, and that's just the typical sales tax that a city or county receives from any retail sales. So there's no particular sales tax revenue dedicated to cities. It's just what you would normally receive in the course of any retail transaction. And of course, the biggest question out there right now is what will the federal government do? The Department of Justice has not weighed in yet. The governor has asked the Department of Justice what their plans are, and they've said that they will get back to us on that. So we're still waiting to hear what the Department of Justice will do. It's important to remember that the Department of Justice can't stop the state from decriminalizing possession of marijuana. That's a state law. The state's not obligated to enforce the federal law. What it means is that the feds could come in and arrest and prosecute somebody for possession, but they can't require the state to do so and local law enforcement to do so. What it does mean is that they could come in and try and take some action in stopping the state and the Liquor Control Board from moving forward with regulations and licensing. And as many of you may be aware, the Department of Justice has issued memos regarding medical marijuana, and that may provide some insight into their position. But at this point, everybody's just waiting to see what the Department of Justice will end up doing, if anything. So that's a brief overview of the initiative. And our next speaker is Ian Goodhue with the King County Prosecuting Attorney's Office. Ian is going to cover some of the criminal justice issues associated with this, and hopefully his sound quality will be better and he's not echoing.
Hello, Candace. I'm sorry, can you hear me?
Yes, Ian, we can hear you.
Great, okay, sorry.
So, Ian, I'm going to say I was going to read your bio, but in the interest of time, I think I'll just let you go ahead and start.
Perfect. Yes, it's not that interesting, so I will start. So thank you, everyone, for hearing me out on these issues. Again, my name is Ian Goodhue, and I'm Deputy Chief of Staff for the King County Prosecutor's Office, working for Prosecuting Attorney Dan Satterberg. I have some slides to go through and some selected criminal issues. My guru and counterpart, Mr. Tom McBride, is also on the phone call, so he may be able to help answer questions later on in the presentation. So if I could have the first slide, please. Okay. So as Candace mentioned, December 6th, of course, is the first important date that prosecutors and law enforcement face regarding the decriminalization of simple possession of 1 ounce or 28 grams of marijuana. That will begin on December 6th. The initiative, however, established a very bright line for who can possess that 1 ounce of marijuana. anyone under the age of 21, still it is illegal to possess any amount of marijuana and can be prosecuted. Obviously, offenders who are under the age of 18 would be prosecuted in our juvenile courts. Individuals who are 18, 19, and 20 years old still would be prosecuted in our district and municipal courts for the crime of simple possession of marijuana. The issue that looms come December 6th for prosecutors and police officers is, of course, it will be legal for persons over the age of 21 to possess up to 1 ounce or 28 grams of marijuana, but there is no legal mechanism for a person who is not medically authorized to possess marijuana under the Medical Marijuana Act to obtain that marijuana, not to grow it, not to buy it, or trade for it. Now, of course, as police officers and prosecutors know, the medical marijuana law has for many years created some uncertainty in how to enforce the law in terms of the possession of marijuana and particularly the growing and distribution of it. I think the uncertainty that will exist come December 6th for prosecutors and police will only increase. And if I could just back up a second, when it comes to the simple possession, some of you may be aware that the week after the initiative passed, my boss, Mr. Satterberg, as well as a few other county prosecutors around the state announced that we would be going back and taking our simple possession cases that were pending a trial or that were pending a filing decision and go ahead and dismiss and decline to file those cases. For us here in King County, that was about 130 cases that were pending filing and about 40 cases that were already filed and pending trial. But back to the issue of where a person who can now legally possess marijuana can obtain the marijuana. Come December 6th, prosecutors and police officers will have the decision to make that when catching someone in the act of purchasing or trading for small amounts of marijuana, that is still illegal under state statute, and that we would either charge that individual with possession with intent to deliver a controlled substance or actual delivery of a controlled substance, and then for individuals who are manufacturing the marijuana, they would face a manufacturing charge. Legally, we're on solid footing because the initiative did not affect any of those statutes, at least until we have a legal and safe regulatory system to buy marijuana. But the equities of those cases will obviously be a challenge for prosecutors because if you have a small amount of marijuana, for example, that's being purchased or sold by two individuals and your police come across it, you can obviously charge and prosecute that crime as a felony. However, the possession of the substance is legal, and I think there will be lots of discussion being exercised across the state in that regard as to how we proceed. But I think the point has to be made that for the time being, if we do not have a safe and legal manner for individuals to buy marijuana, then those that are already illegally producing and selling it may have that bigger of a market to sell their goods in. So as the initiative calls for, the Liquor Control Board has until December of 2013 to develop the regulatory system for the manufacturing and dispensing of marijuana through producers, processors, and retailers. The initiative also is very specific in defining what will qualify as marijuana for that producing, dispensing, or producing, processing, and dispensing procedure or system. It's marijuana that will meet the definition if you have THC, the active ingredient in marijuana, of a content greater than 0.3% by dry weight. As Tom McBride and I have looked at that issue and others in prosecutors' offices, we believe that that is meant to make a distinction between other products that are made from hemp that have much less of a value in terms of ingesting it or intaking it as a drug and more as a product. The most common that I'm at least aware of is rope or other products or clothing that's made out of hemp. And so that's the dividing line. We have checked with our crime lab experts. They will be able to establish a testing regimen to make that determination. That's not an easy thing, obviously, for the lab to take on. The contemplation of more resources and more people power to do that testing, of course, is something that is always a concern to the State Patrol Crime Lab, which prosecutors and police rely on regularly, obviously, for all sorts of criminal testing. I want to move now to what was the most talked about provision of the initiative besides, obviously, the legalization of simple possession, and that was the driving under the influence prong of the initiative. The initiative writers, the most prominent of which is here from Seattle and King County, New Approach, the campaign director, Allison Holcomb. She and I have spoken about this, obviously, several times, and their intent, the initiative creators, obviously, was to have a very strong component within the initiative when it comes to driving under the influence of marijuana. From a strategic perspective, they felt that that is a way in which they could alleviate some voters who were undecided on how they were going to vote on the initiative because of the danger of driving under the influence of marijuana. They felt that they had a very strong provision in the initiative that would potentially sway some voters. I think the vote of the people bore out that theory, and they were correct in part. This, of course, was the most controversial or most talked about provision of the initiative because there were a whole mix of individuals and organizations who opposed this prong of the initiative because they felt that it was too tough on individuals who already, particularly those who already used marijuana for medicinal purposes, because the 5 nanogram per milliliter of whole blood measurement level that creates a per se prong for prosecutors to be able to prove the charge of driving under the influence, the opponents of the initiative felt that was far too low of a level. Their argument being that there are hundreds, if not thousands, of individuals who use marijuana for either medical or non-medical reasons who have that level of marijuana in their blood even days after ingesting marijuana. The truth is that the initiative is very clear on this point that it is 5 nanograms of active THC, THC being the component of marijuana that, of course, people ingest it for the effect, but also the component of it that would impair someone's ability to drive a motor vehicle in a safe manner. So the initiative is very clear on that point that the nanogram limit is for 5 nanograms, is a measurement of 5 nanograms of active THC, and the labs currently and already have that capability. The initiative is also extremely strict on driving under the influence of marijuana for minors. It sets a zero tolerance policy. So any measurement of active THC in a minor system, and they're subject to prosecution for DUI. That in and of itself is a much greater change in the criminal law than the 5 nanogram per se limit for adults. It will undoubtedly see some increase in prosecution of minors under the influence of marijuana and THC. Now, the measurement of THC, again, the most controversial component for driving under the influence of the initiative, the measurements that the labs can conduct through a blood draw will look to measure the THC level within the last 2 hours of driving. That's not dissimilar from our current breath and blood alcohol tests for the level of alcohol in one system. However, unlike the breath and blood tests for alcohol, prosecutors and police don't have the ability to retrograde, in a retrograde fashion, calculate the amount of blood or breath alcohol that one would have as we do under DUI for THC and marijuana. That's simply not, we're not capable of doing at that point, to extrapolate back from the time that we take the test and discover someone has 5 nanograms or more of THC to try to determine what they had while driving. Now, and as we've noted here in the PowerPoint, just like alcohol, there's always the issue of consuming the substance that impairs your driving prior to the blood test, but after being caught in driving. I think the most, and prosecutors and police have been talking about the issue since the initiative passed, and to counter some of what the opponents declared about a massive increase in the prosecution and the arrest and prosecution of individuals driving under the influence of marijuana, the truth is police and prosecutors have long enforced the law when it comes to driving under the influence of THC. And the way we've done it, and it's the most commonly misunderstood component of our driving under the influence laws, whether you're talking about THC or alcohol or any other substance, is there's 2 ways in which we can prove that someone is driving under the influence. You can have a test like we do for alcohol of 0.08, or you can show that someone's driving was affected by the use of a substance, or their driving was impaired. And we have been prosecuting here in King County, as have the other 38 counties for years, cases in which individuals are under the influence of marijuana, some prescription medication, obviously harder drugs, cocaine, heroin, or methamphetamine, and we've been proving that they're driving under the influence of these substances by showing through the evidence that the police gather at the time of the stop and that we present in court as prosecutors, the fact that this person's ability to drive a motor vehicle in a safe and legal fashion was impaired. We plan to continue to focus on showing signs of impairment, even when we may have a THC nanogram level that meets the per se rule of 5 or more. We're still going to look for signs of impairment, just like we do in driving under the influence of alcohol cases, because frankly that helps us convince the jury that that's the right thing to do in terms of convicting an individual of a criminal offense. So we, WAPA, and working with our partners with the sheriffs and police chiefs, intend to continue to stress that officers should follow their current training when it comes to investigating impairment, even if you intend on getting a blood alcohol or a blood draw that may show a THC limit of 5 nanograms or more. We want to continue to gather that evidence as much as possible. The blood test is authorized under the same implied consent statute when there's probable cause to believe that an offender is under the influence of a drug. So again, that doesn't change from current practice just because we now have a 5 nanogram limit. Officers still need to be able to articulate that they have evidence of impairment, which leads them to get that blood draw probable cause established so that you can take the blood from an individual. And again, just to stress, obviously the impact of this is even greater when it comes to minors because any detection of THC can lead to the prosecution for DUI. So again, we are going to stress with police officers as well as prosecutors who are taking these cases to court because we do anticipate, obviously, challenges from the DUI defense bar, which is very active in several counties, if not across the state. We expect a variety of different arguments to be made by the defense bar about the 5 nanogram THC level. and we're going to stress with them that we're going to want evidence of impairment in addition to just that test. Again, this slide just stresses the very strict requirements for any individuals under the age of 21 driving without the presence of THC. In the past, we would obviously look for more evidence of impairment even under the age of 21 to show that. Here, by the strict reading of the law, we don't need it, but again, we'll still look for it.
Hey, Ian?
Yes.
Can you hear me?
I can, yes. This is Tom.
Thank you. I just wanted to throw in one point, that last point on the previous slide about the misdemeanor presence rule. Since under 21 THC is new, it's not included as an exception that allows the officer to arrest when the crime occurred outside their presence. So you may have some fact patterns where the officer didn't see the driving by the juvenile. Those are not situations where you can do the arrest on the gross misdemeanor, and that's a little different maybe than what we have that exception for DUI in there. We just are going to have to update some of these statutes, but for right now, that little point I just wanted to highlight.
Thank you, Tom, and I missed that point. It's a lot of you know from law enforcement. It's a unique rule that we have a common rule that on misdemeanors the act has to be committed in the officer's presence, and there are exceptions to that rule, as Tom said, DUI being one, but that's not been addressed with the creation of this new violation for someone under the age of 21. So again, and I'm sorry, I'm just taking me a couple hits to move through my slides. So again, stressing that when moving to take a blood draw in investigating DUI with marijuana or THC on board, we're going to need to be able to establish probable cause prior to the taking of that blood that the driving was somehow impaired, and that evidence will still be crucial at trial. And the law enforcement officers will tell you from experience that in pulling over a motor vehicle where they've suspected that individuals within the car are ingesting marijuana or have ingested marijuana, and that it may be impacting the driver's ability to drive safely. Obviously, you need to tie that evidence to the driver, him or herself, as opposed to the other individuals in the car. Again, the number of different ways in which we can gather evidence to show impairment in addition to the blood draw, all of which are listed here. So the blood draws are currently in effect already for certain serious accidents or collisions that may involve the use of alcohol or injury, as well as drugs being on board. Follow your procedures when it comes to drawing blood, who you would actually go to for that particular act. Okay. Off of DUIs and onto another legal issue that's been of some discussion amongst WAPA and the sheriffs and police chiefs. Obviously, law enforcement has used in the past highly trained dogs, canines, for drug sniff tests in order to establish a probable cause for a search or at least an initial investigation. The question has come to us now that it's a legal substance. What impact will that have in terms of using the trained dogs for such a search and applying for a search warrant? Obviously, marijuana in one state, 28 grams or less is legal for someone to possess. Over that, it's illegal for them to possess. And then even after December 2013, individuals who are still choosing to manufacture and distribute marijuana outside of the regulatory system that's established by the Liquor Control Board will still be violating state law as well. So essentially when an officer comes upon an incident or initiates an investigation to try to determine whether the substance is being possessed legally or illegally, or whether the individual that the officers are investigating is possessing an entirely different controlled substance that the dog may be alerting to, we have to be careful and alert we have to be careful in describing when a dog alerts in a situation like this, that obviously there's always the possibility that they may be hitting on what they've been trained to hit on in the past, which was once always an illegal substance. Except, of course, if you're in a medical marijuana situation, which that wouldn't have affected the initial investigation because that was an affirmative defense that could be presented later at trial. Now we have a situation where dogs that are previously trained obviously could be alerting on what is now a legal substance, but we need to be able to describe what additional evidence makes the officer believe that there may be illegal activity going on, and then include in that description, obviously, that the dog alerted and what was later found was either a legal or illegal amount of marijuana. You would only describe the legal amount of marijuana if you found other activity that was illegal and you were proceeding with your search warrant, your prosecution. Public consumption. We are just now starting to grapple with that issue here in King County. I'm in discussions with the Seattle City Attorney's Office and some other city attorneys about how we're going to go about dealing with what may be a decent increase or an increase in the number of infractions we see for use in public. Obviously, an increase over zero is an increase. It is a civil infraction, a ticket, and a fine to display, open, or use marijuana in public, even though it is now under 1 ounce a legal substance. However, law enforcement officers do not have carry stop authority, meaning just because they observe the open use of marijuana in public, that does not give them the ability to make that initial criminal investigative stop and detain an individual to investigate for a short period of time. It's a civil infraction. The officers need to initiate contact, issue the infraction, and essentially get in and get out as quickly as possible, unless they can articulate some other behavior, some other activity that suggests a criminally illegal behavior or activity. If they cannot articulate that, then the law is very clear that the only time that should be taken is to issue the citation, and send the person on their way. What is probable cause to cite, or what is a articulable basis to cite someone for the infraction? The most common instance we assume will be both the vision or seeing someone smoking or taking out the substance, but then usually it's going to be smell. And officers have in the past been trained on the smell of marijuana, and obviously through their years of experience in enforcing the law, when it comes to being a legal substance, they have that training and experience to rely upon in articulating it later. The individual will have the ability to contest the infraction just as you can contest traffic infractions. We'll have to sort out exactly what will meet the threshold. Obviously, because it's a civil infraction, we don't have to prove that they were using or opening or displaying marijuana in public beyond a reasonable doubt, but only by a preponderance of the evidence. But the infraction impact could be great when it comes to our municipal and district courts. There's no arrest authority because it's a civil infraction, and again, the issue of, in Section 21 of the initiative, it's going quickly on me here, spells out that it's a Class 3 civil infraction under RCW 780. I want to get to... Again, no Terry stops. The offender may only be detained for a period of time as it takes to issue the infraction.
Ian, does that pretty much wrap up your presentation?
It does. I just want to make one more point on that particular issue, Candace, and I'm sorry, for some reason the keyboard was jamming on me. So when it comes to the infraction, and again, as much as Tom articulated on the other issue of certain misdemeanors, infractions are really, you're going to be safest if officers are issuing those based upon, it occurring within their presence and not relying on the report of others. Because you're prohibited from issuing an infraction in most instances where it's not occurring within the officer's presence. That's just a small number of the legal issues that I think police prosecutors are going to face in the implementation of Initiative 502, and so I hope that was helpful.
Thanks, Ian. We really appreciate it, and I know we've had a number of questions on the screen. We'll try and get to those at the end if we haven't answered them already. Next up, we're going to have Jennifer Harda from Sebris-Busto-James talk about some of the HR issues that cities and counties need to be aware of and what this means to you as employers. Jennifer, are you on the line with us?
I am on the line. Can you hear me?
Yes, awesome. Again, I was going to read your bio, but in the interest of time, I'm going to skip that and I'll let you go ahead and get going.
Thanks so much. Before I start, can I ask a technical question? Am I in control here of the PowerPoint then, I assume?
No, we will control the PowerPoint for you.
So I was wrong. I'm glad I asked. So I'll go ahead and get started then. Thanks so much, everyone. I appreciate the opportunity to speak with you. Obviously, it's an abbreviated time period, and there are, so I'm going to touch the surface of issues related to marijuana legalization as they affect or do not affect, as the case may be, employment issues and issues in the workplace. There's certainly been a lot of news media things, a lot of excitement, to use one adjective, surrounding the implementation of this new law and all the changes that are being impacted. Ironically, I think, as I'll discuss and share, the impact on the workplace is actually, I think, the general consensus among employment practitioners, at least at this point, and some of it is guesswork, but as I'll discuss, I think we have our arms pretty well wrapped around the fact that the impact is actually likely going to be somewhat slight. At least from a legal perspective. There may be some more specific practical implications that I'll talk about. If you can go ahead and go back to the last slide. I'll talk about the areas I'm discussing. Again, impact on the workplace, and then from a more practical standpoint, drug policy considerations, union considerations. And then a real kind of gray, somewhat murky area, somewhat covered a little bit by Ian in terms of testing capabilities, is going to be determining impairment at the workplace. So if we can go ahead and move on to the next slide. So impact on the workplace. As we all know now, on November 6th, Washington voters pretty unequivocally approved Initiative 502, and which decriminalizes certain cultivation, sale, possession, and use of marijuana. Again, Ian covered all that at great length. What is missing, what is notably absent from the law, is any discussion of impact on the workplace. So, next slide, thank you. So again, as I mentioned, from a legal standpoint, impact on the workplace is really going to be quite minimal. What I502 does not do is it does not legalize marijuana use in the workplace. Again, it's really isolated to decriminalizing certain uses. And to that end, marijuana use and possession remains illegal under federal law. So we are still dealing with federal legislation that most certainly criminalizes the marijuana use. So in terms of guesswork, we have a law that's silent on what it does in the workplace. We have federal law. And then the courts, of course, will always get involved in terms of interpreting the law. We have a little bit of able to forecast a little bit in terms of what the courts will do. In 2011, just last year, the Washington State Supreme Court took up a similar issue under the medical use of marijuana Act, which still stands today. You know, as we know, that is a law that decriminalized marijuana use for medicinal purposes under certain contexts. So what happened with this Roe versus customer care management case, as we could speculate would happen under that law, and as we can likely speculate will happen under the current law, that someone will be terminated for marijuana use and challenge it. That's exactly what happened here. There was an individual, Roe is not her real name. She went under the name of Roe because of the federal criminalization of marijuana. And she was hired as a call center employee with the defendant in this case. And her position was contingent on her successful passing of a drug test. This was a private employer. And she previously had been granted medicinal use of marijuana. Apparently she suffered from some pretty severe migraine headaches and had used marijuana medicinally only in her home, or so the evidence showed. She failed the test. She tested positive for marijuana, and the employer terminated her. She then challenged that decision in court, claimed that she had been wrongfully discharged in violation of public policy. The public policy she pointed to was the Medical Use of Marijuana Act. The case went up and ultimately landed at the Supreme Court, and the Supreme Court held that the Medical Use of Marijuana Act did not, in fact, protect employees from discharge, even if that use was authorized medical marijuana use off-site and or on the employee's own time. So while this case certainly centered around the separate statute, the Medical Use of Marijuana Act, if we can go to the next slide, that'd be great. It is really enables us to kind of look to the future and see, guess or presume what the Washington courts will do under similar circumstances under I502. And it is very likely that Washington courts would use Roe, the Roe decision, as a basis for deciding employment-based challenges to I502. Under similar circumstances, if someone were tested under certain circumstances and the test came out positive and were terminated, any similar challenge, the same reasoning would apply. And under that reasoning in Roe, it's a likely conclusion that I-502 would permit an employer to continue to discipline or discharge an employee or refuse to hire an applicant based on marijuana use. It just seems extremely unlikely, if not completely unreasonable to guess that in a case where under Roe, the argument was that this person was using marijuana for medical purposes, it seems very unreasonable that the court would then change course and reason otherwise and, in essence, call it a wrongful discharge when someone had been using it under the new law, I-502, for recreational purposes. So going forward, I think we're all, employer practitioners are pretty confident that the impact on the workplace in that capacity will remain unchanged, and employers will continue to be able to discipline and discharge employees, refuse to hire applicants and whatnot based on marijuana use. So to that end, talking a little bit more then about practical considerations, more specifically drug policies and drug testing. Again, this is an area where really nothing has changed. Employer authority to enact drug policies remains unchanged. Employers retain complete authority subject to any applicable notice requirements and specifically collective bargaining agreement restraints or obligations. Next slide, please. Thank you. So to that end, this is a good time for employers to really be reevaluating their policies and updating them to prohibit marijuana use. Marijuana use under Washington law is now really in a similar category to alcohol use. It's basically a legal substance that can be regulated, prohibited at the workplace. So similar to alcohol, employers may require testing, may discipline for policy violations, and certainly may regulate use and impact in the workplace. And then beyond that, there are certainly issues, again, as I mentioned at the outset and as we're all aware, marijuana use is still unequivocally a violation of federal law. It's prohibited by federal law. So to that end, employers that receive federal funding should notify employees that despite 502's passage, nothing has changed in terms of the employer's existing tolerance for marijuana use and enforcement policy. And for instances where the Drug-Free Workplace Act applies, or when U.S. Department of Transportation standards apply for commercial licensing, and those testing requirements apply, there's got to be a zero tolerance policy to avoid violating those statutes and standards that are applicable to employers when they apply. So for zero tolerance policies, those policies should certainly make clear that illegal drugs include those prohibited by both state and federal law. That's going to be a key component here, because zero tolerance policies that simply say they prohibit illegal drugs and are unclear on what that is, what's included, that leaves room for an argument that marijuana is not unlawful under state law. And so, the employee could argue that he or she was not, in fact, using an illegal drug under the policy and under state law. So policies for zero tolerance policies should certainly highlight that illegal drugs most certainly include those prohibited by federal law. Considerations for less than zero tolerance policies. Again, marijuana under state law is going to be now similar to alcohol. So policies may treat use similar to alcohol use, may prohibit or may say no on the job impairment, may implement reasonable suspicion testing, just as alcohol testing has been conducted in the past under Washington law. That's going to be similar here for marijuana, and then can also prohibit on-premises possession at the workplace. Differences between regular and safety-sensitive employee positions, really, again, no change here. No change as to on-the-job usage. Again, as I specified before, in circumstances where the Drug-Free Workplace Act applies and U.S. Department of Transportation standards and testing, it's going to have to be zero tolerance in order to ensure compliance with those requirements. The same constitutional issues for public employers remain for testing. Same issues with regard to safety-sensitive positions. Basically unchanged constitutional testing issues. Reasonable suspicion or for safety testing can be conducted for safety-sensitive positions. Union considerations. It's very likely that union employers should expect unions to potentially request changes at the bargaining table. Again, items that remained unchanged. The duty to bargain on drug testing and changes to drug testing for employees remains. No change there. One practical change here may be in the demonstration of good cause for discharge with a positive test result. We'll discuss testing in the next slide, and that's going to be an area where it's going to be a little bit difficult. But reliance in demonstrating good charge or good cause, reliance on safety reasons may be a little more difficult. where employee use is off-duty and the individual is not impaired at work. And it's certainly likely that unions will be eager to test just cause principles when individuals are terminated for marijuana use, positive test results, and arguable impairment on the job. And that brings us to the final topic of determining impairment. This is, from my perspective, the area that's probably most up in the air. It's unlike alcohol or some drugs, and again, Ian discussed this earlier. Marijuana can remain detectable in a person's body and blood work for weeks after its use. So unlike in the past with alcohol testing, where you have a smaller window and it's easier to test for impairment on the job within a certain number of hours, there are definitely going to be some challenges in this area. The result is basically that current tests will likely detect use and not necessarily impairment. I don't have my arms really around the various options or potential options at this point, but other testing options may become available with time and research. And one of the things that I took note of when Ian was speaking is the various, it's blood tests, of course, but tests being able to detect levels of active THC. And so as those type of testing options evolve, it may be that the employment testing will evolve with it. But in the meantime, on-the-job impairment is really going to be a difficult and more of potentially subjective issue that's may not necessarily be able to be substantiated by at least drug testing in its current form. And so, as has been the case with alcohol, impairment certainly, we don't have to hang our hat totally on testing. That's a nice backup. But same types of impairment that we're always looking for in the workplace for alcohol-related use is really going to be applicable with regard to, concerning ourselves with whether someone is impaired on the job as a result of marijuana use. So, in sum, at the end of the day, the legal requirements here, what the law is actually doing, it's not changing the workplace. It's speaking solely to decriminalizing marijuana. And the practical implications that are then imposed on the workplace are in various degrees. Some remain unchanged. Some are really in ensuring that policies are updated to, to unequivocally enforce no-use policies, or to revise policies to treat marijuana use similar to alcohol, and to really follow those same similar practices.
Jennifer, thank you very much for that presentation. We'll have you hang on the line, hopefully, to answer some questions that we may get from our folks afterwards. Right now, I'm going to go ahead and transition to Rick Garza with the Liquor Control Board to talk about what they're going to be doing over the next year. Rick is the Deputy Director of the Liquor Control Board, and again, I'm skipping the bio reading in the interest of time. So with that, I'm going to turn it over to Rick.
Thank you, Candace. Let me just begin by sharing with you that, obviously knowing and looking at the polling that was occurring before November, the board began to lay out a contingency plan for implementation of Initiative 502. Interesting enough, because of the experience we had with 1183, we used many of the same resources and teams. Just want to let you know that we just ended our first meeting with the external team. These are all the divisions, all the agencies that are impacted in assisting the Liquor Board in implementation. Department of Agriculture, obviously, because there's a grower section to this, State Patrol, Revenue, Health, DSHS, and we just ended that meeting, and we're getting some information with respect to concerns that folks have, and we'll be working and meeting regularly with this external team. Internally, just so you know, very similar to 1183, if you're aware of the rulemaking that occurred there and the changes that we had to make to implement a privatized system for liquor. We've got several teams that have been put together within the agency. We're also going to include those external agencies and agencies of the state in many of these teams to help us. And so I want you to be aware that those teams have been meeting for the last month. Obviously, when you're looking at something that we all have very little knowledge of, the first thing that we're involved in right now is initiating an RFP to get some expertise with respect to the product itself. We know that Colorado, in their medicinal marijuana law, has created a regulatory structure. We're going to be working directly with Colorado to learn more about that. Interesting enough, looking around the country and even the world, we thought we might find and gain some expertise with respect to how do we create this regulatory system by what others have done, but we found that, in fact, there is no other state or country that has created a regulatory system to legalize marijuana. They've legalized marijuana, but they haven't created a system other than medicinal marijuana for Colorado. So we'll be looking for some expertise. We believe there's some out there in the country, California, and so we will be developing an RFP in the next week or two. We really need to gain some knowledge of the product before we create the system. Obviously, there's lots of interest that we're getting from the public. We've created a listserv. Please go to our website, which you can see in front of you. We've got a web page devoted to providing information to the public. We'll also be reaching out to stakeholders once we have a proposal, and we'll really be using the rulemaking process for that. But that will be an opportunity, just as we did with I-1183. Go to our website. All the information that you need, that we have, will be available there. And also, after we get the RFP and we've got some assistance from a consultant with respect to the product that we're going to be regulating, we'll begin rulemaking, and that'll be a very transparent process that we use, just as we did for 1183. We'll also be looking at, as we get a better understanding of the product that we're regulating, we'll be going out to the state to hold hearings to get information from the public regarding our implementation of the new law.
Thanks, Rick. I know the Liquor Control Board has a lot of work to do over the next year, and that completes our formal presentation today. We have some questions that have come in through the process here, and we're going to try and address some of those for you. Just again, a thank you to our presenters today, Ian, Jennifer, and Rick, and to our partners who helped pull this all together. And thanks to everybody on the line who's been patient through our technology ups and downs here. We're still a work in progress, obviously. So we're going to go to some of the questions that have come up and see if the brain trust between a few of the folks we have here in the room at AWC and our speakers who are still on the line can maybe address them. So the first question is an HR-related question. So Jennifer, if you're still there, this might be for you. If an employee uses legally off-duty, but a drug test shows positive, do they then discipline them based on the Roe case? And what about DOT urine tests?
Okay, I missed the first. I was unmuting myself, and I missed the first part of the first question. Are you able to repeat it?
Sure. If an employee uses legally off-duty, but a drug test shows positive, are they subject to discipline based on the Roe case? And then the second part was, what about DOT urine tests?
Okay, so the first question is really addressing off-duty use. And what that's going to depend upon, in a nutshell, I think, is what the employer's policy is, whether it is no tolerance policy, absolute prohibition of any form of marijuana, illegal drugs, including any of those under federal law, which would include marijuana. Or if the employer, in essence, treats marijuana similar to alcohol use, and that would, in essence, be a prohibition of alcohol, or in this case, marijuana use that impacts performance at the workplace, use at the workplace, things of that nature. So if the policy is the latter, and that is that it treats it similar to alcohol, the question is really going to be whether there is a policy violation, and whether it's a performance-related violation, or something else that could then lead to discipline. If there's a zero-tolerance policy, and that is the employer absolutely prohibits the use of illegal drugs, including those prohibited by federal law, then it would be similar to what happened in the Roe case, and that was a circumstance where, in essence, they had a zero-tolerance policy, and this individual's drug test came back positive, and so she was terminated for that basis under the zero-tolerance policy. So, the short answer is it depends on what the employer's policy is. Zero tolerance, the answer is yes, it's a terminable offense. Less than zero tolerance, it's going to be subjective based on what the policy violation was as applied to the facts. And then the second question was related to DOT testing. Is there something specific to that? I think I saw something in the Q&A that asked, I think it was basically whether it says, will employers who test under DOT's regulations have issues, problems with employees who want blood tests? I'm not sure what the specific DOT testing question is.
Okay, Jennifer, we'll get back to that one. We'll see if we can get it better defined. I have another HR/law enforcement related question in regards to the absolute prohibition for police officers. And is that dependent upon the agency, or is that just where would that absolute prohibition for law enforcement officers come from?
I'm not sure if anyone else wants to jump in on that, but specifically I think for an employer standpoint, that can fall into the category of safety-sensitive positions, where the same types of standards will apply in terms of testing for those positions where there's basically, the government has a compelling interest in testing to ensure that individuals in those safety-sensitive positions are not using illegal drugs.
Jennifer, I'll jump into Tom McBride with the Prosecutors Association. I think you're going to find that by agency policy, most likely the details of zero tolerance under state and or federal law. The one thing I thought might come up is I know that blood testing at the crime lab can distinguish between active THC and carboxy-THC, the metabolite, and that might be something where I don't know if urine tests do that, and so an agency that doesn't want to have zero tolerance but wants to have a impairment tolerance may need to look at whether blood testing allows them to make that distinction or not. So we're going to raise these questions with Dr. Fiona Cooper at the Tox Lab, but it may be something where if you want to do something other than zero tolerance, you may need to move to a blood testing standard if that'll hold up in terms of distinguishing between impairment and just a prior use that no longer is affecting you physically.
Our next question is in terms, I believe, of law enforcement impacts, and it is, do you need a search warrant for a blood draw? Ian or Tom, maybe, if you'd like to weigh in on that? Tom.
So I think the authority I would use to get the blood draw would be under the implied consent statute, which speaks to allowing you to get blood on the suspicion of drugs. And in one of the slides, you saw the reference there. There are situations where we get a search warrant for blood, but I think at this point, I would go under the implied consent statute. And that's probably something where we ought to put out another advisory on.
The next question that I've got here is a land use related question, and maybe Rick can help answer this one. And it is, can jurisdictions implement restrictive policies to limit where producers, processors, and retailers are located?
I don't see anything in the new law that suggests that. Pretty similar, I think one thing to be thinking about is the way that the law was crafted. It's very similar to how we deal with alcohol. So the three-tier system of the producer, the processor, and the retailer, requirements for those licensees, we're probably going to look again at the Colorado regulatory system because it has some real controls in there about what happens at each of those spots. But I would suggest take a look at what the new law says. I don't see anything that suggests that the local jurisdiction, similar to 1183, has the ability to impose restrictions on where those are located. Certainly the state will be able to impose those kinds of restrictions when we do the rulemaking on it. I'm not sure the locals have the ability to do that.
Will locals be able to use their typical land use authority to zone for commercial?
Well, they already do that now, and so there'll be issues with respect to where the growers' licenses can be held and where and when, and again, zoning depending upon business versus residential. But again, unless I'm missing something or someone has more information there, I didn't see anything specifically that gave local authorities the ability to impose zoning restrictions with respect to where they're located, whether they're growers, processors, or retailers.
Okay, so think of them like alcohol at this point.
Yeah, I would.
So we've got a lot of questions coming in, and we're trying to juggle them. It's a little hard for us to get them off the screen and ask them. We are going to try and gather up these questions and put them together in sort of an FAQ sheet and have it out afterwards. And we do plan to post today's presentation on our AWC website. We'll share it with our partner organizations as well, and I anticipate that they'll post it on their websites. So we'll get this information out so it can be shared. You'll have copies of the PowerPoint. And let's see if we've got any more questions we can try and take on right now. So I think we are pretty much going to be able to wrap up a little bit early. Again, thanks to everybody who joined us today. Thank you to Ian, Jennifer, and Rick for putting this together in short order. It was our attempt to try and answer some of the questions that you may have. As I mentioned earlier, there are a lot